Mr. Davis Bay, can you hear me? I need you to unmute yourself.
Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis as this to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021. Approximately around the time when the case was first initiated. I did upload and file on the record.
The hearing opens with Judge Morales calmly laying out the ground rules, 10 minutes per side for argument. Antoine Jermaine Davis Bay, representing himself once again, begins his motion to reconsider. From the start, the tone is familiar. Legal jargon mixed with sovereign rhetoric, and a desperate attempt to sound authoritative. The judge remains composed, granting him full opportunity to speak, a gesture of fairness that Davis Bay interprets as an opening for victory. As Bay begins rambling about unlawful arrest without a warrant, it becomes clear that this will not be a structured legal argument, but a lecture in pseudo-law. The courtroom, patient but wary, braces for another round of sovereign theatrics dressed as legal defense.
It's a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed.
Davis Bay launches into his reasoning, claiming the entire case stems from hypothetical suspicion rather than a concrete crime. It's the kind of word salad sovereign citizens love: dramatic, empty, and circular. He insists the state had no probable cause for the arrest or search, but never clarifies what actual evidence supports his claim. Instead, he repeats legal phrases out of context, referencing Texas law and federal law like interchangeable props. The judge, to his credit, lets him continue without interruption, though his patience shows in the small corrections, asking Bay to face the camera and slow down for the court reporter. The imbalance is obvious. One side speaks law, the other performs it.
Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report, and it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony, affidavit, or probable cause to.
Your Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
But this was all inside my motion as exhibits and as a brief.
Allegations.
When Bay repeats that his arrest stemmed from an unlawful traffic stop, the narrative feels like déjà vu for anyone familiar with sovereign logic. He mentions that the related marijuana charge was dismissed, using that as proof the entire stop was unconstitutional. But legally, he's missing the point entirely. Dismissal of one charge doesn't automatically erase the validity of the stop. This is courtroom chess played by someone who only knows checkers. The judge stays neutral, listening, while the audience, if this were a real courtroom gallery, would likely exchange knowing looks. It's another classic sovereign misunderstanding of how probable cause and due process actually function.
Fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed, case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine,
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
yes, ma'am. Yes, sir. Wong Sun is W-O-N-G. First name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to this these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent.
As Bay continues, he attempts to anchor his claims in constitutional language, invoking the 5th and 14th Amendments and the Texas Bill of Rights. To the untrained ear, it sounds impressive. Words like due process and arbitrary government action roll off his tongue with confidence. But for anyone versed in law, it's hollow rhetoric. His violations don't match any legal precedent, and his argument reads like something copied from a sovereign forum online. Judge Morales doesn't interrupt. He knows that allowing Bay to fully present his misunderstanding will make the ruling cleaner and less disputable. It's an unspoken judicial strategy. Let the pseudo-lawyer bury himself in his own script.
As Mr. Bay had access to discovery in this case, he was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was.
Will you
Okay.
spell that, sir?
Last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the police,
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since, at the very least, October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed, so we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor, so he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That, in and of itself, constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, Mr. Bay.
Can you please
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State.
His next complaint centers on an alleged missing affidavit of probable cause. He claims he requested the police report and received a blank document, as if that proves conspiracy. In reality, this is standard discovery procedure. Some reports don't include officer affidavits because those are filed separately or incorporated into the case file. But Bay sees every gap as proof of corruption. He repeats, failure to sign affidavit, as if it's a magic spell that nullifies jurisdiction. The courtroom dynamic is fascinating here. The judge lets him speak uninterrupted, while the prosecutor listens quietly, waiting to dismantle these pseudo-legal myths when it's their turn.
Again, this is as alleged by the state, at which point in time the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate, so he's claiming he hasn't had a fair hearing but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E, v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, in that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee.
Starts veering off topic, invoking Texas criminal procedure codes and making wild claims about unlawful search and seizure. He insists that odor of marijuana alone is not probable cause, citing random laws without context. The prosecutor finally objects, noting that his arguments fall outside the motion's scope. The judge immediately sustains it, reminding Bay to stick to the issue at hand. Yet Bay protests, insisting that all of this is within his motion. It's the typical sovereign tactic: overwhelm the court with confusion, then cry foul when reined in. Judge Morales, unshaken, reasserts control, showing exactly why experience matters in these sovereign showdowns.
I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right. Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. The prosecutor mentioned that I had a probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. Never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021. Bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond, before a complaint was even filed, and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings, because at first it was 2 judges. Christopher Morales, and another lady, judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never took place. Also, okay.
When Bay shifts to citing Wong Sun versus United States, it's clear he's desperately reaching for legitimacy. He spells the case name for the court reporter like a student showing off vocabulary. The fruit of the poisonous tree doctrine is a real concept. Evidence obtained unlawfully can be suppressed, but Bay applies it incorrectly. He assumes that because a marijuana charge was dismissed, all subsequent evidence should vanish. The legal reality is far less forgiving. A dismissed charge does not retroactively invalidate the arrest unless the initial stop was ruled illegal. His argument, though theatrical, collapses under the weight of basic criminal procedure. Next voice.